In this video, we're going to talk about judicial review and the Charter. Prior to 1982, most of the Supreme Court's work was settling disputes over Section 91 and Section 92. These were disputes between levels of government about jurisdiction and authority, really disputes about federalism. However, after 1982 and the entrenchment of the Charter of Rights and Freedoms, there were now new rights that could be subject to constitutional challenges, new guarantees for every individual in Canada. That brought a new potential pool of applicants to the court. Instead of just levels of government arguing about jurisdiction, now every person in Canada became a potential litigant before the court. What were the rights? Well, in the Charter, under the Constitution Act 1982, there were a number of sections that guarantee new rights to individuals. The Section 2, the fundamental freedoms, freedom of thought, conscience, and belief. There's Section 7, the civil rights of life, liberty, and security of the person. The equality rights of Section 15 that guarantee people are free from discrimination. The government can't infringe on these. That's what the Charter was saying, that these rights are guaranteed to people, and laws that the government pass cannot interfere with these rights. But there's always a but. In Canada, we have a pesky thing called Section 1 that says, yes, all of those rights are guaranteed, but they are guaranteed only subject to such reasonable limits prescribed by law that can be demonstrably justified in a free and democratic society. What does that mean? Well, I don't know. What is a reasonable limit? This is basically like saying all of these rights are guaranteed, not a guarantee. We'll give you these rights unless the government decides to take them away. How can that be? Well, it's a very peculiar part of the Constitution. And when the court has to get into this dispute, they usually apply tests. And a test is a legal process or a way of thinking through a problem. When there's a challenge over Section 1, whether a limit is reasonable, the court uses a two-step process, sometimes called the Charter two-step. They ask, is there a violation of a right? And if so, is that violation justified? Because some violations of rights are justified under reasonable limits. A couple examples. Minimum voting age laws. In Canada, you need to be 18 to vote. But that's age discrimination. That is age discrimination under the Charter. However, is that limiting your freedom in a reasonable way? And in this case, minimum voting ages are used in other democratic countries, and therefore they would be considered a reasonable limit. In Canada, the court has ruled that hate speech laws are a limit. They are an infringement on your freedom of speech. However, the court has said that is justified to protect public safety. So yes, these things are fundamental. However, there can be limits, reasonable limits that can be justified under certain situations. It doesn't end there. There's something even more complicated called Section 33, our notwithstanding clause. It allows Parliament or a provincial legislature to ignore judicial review, telling them that their laws are unconstitutional. And they can do that for 5 years. How does that even work? Well, here's one example. In 1977, the Quebec government passed a law, Bill 101, making French the official language in the province. English was illegal, essentially. Pre-Charter, 1977. However, after 1982, and we have the Charter, that can potentially infringe upon people's language rights. And sure enough, somebody brought a case before the court by 1988, and the Supreme Court struck down Bill 101 as being an unconstitutional limitation of people's language rights. So what did Quebec do? They passed a new law, known as Bill 178. Basically said, French only on the outside of building. Yeah, you can have some English on the inside. French letters have to be bigger than English letters. There's a lot of different stipulations. And then they added something to it. They said, we are invoking Section 33 of the Constitution. We know the courts have said this is an illegal law, that it violates people's right, but we are going to continue to operate it anyway, notwithstanding the court's ruling. And it allows provinces and Parliament to do that for 5 years, thinking that after 5 years, the people will have a chance to vote that government out if they don't like them. So that's a very bizarre article in the Constitution. And that is one of two very unique articles in the Canadian Constitution, in the Charter. The Charter period really expanded the role of the courts, it expanded their reach and the importance of the Supreme Court. Everybody became a potential applicant to the Supreme Court of Canada. And it is complicated because we've got these two very unique sections. Section 1, the Limitations Clause, and Section 33, the Notwithstanding Clause.